Our talkback lawyer David Whiting is here to help you with free legal advice. 1300 222 774 is the number. 1300 222 774. David Whiting is our talkback lawyer. He's here to help you with free legal advice. David, good morning to you.
Good morning, John.
Fair bit of legal news around this morning. The Royal Commission is the gift that keeps on giving at the moment, and some of the conduct of lawyers before the Royal Commission into banks and AMP and other financial institutions is now coming under scrutiny as well. Fascinating.
Are we talking about the AMP report?
The Clayton Utz is a major national law firm who provided an, in inverted commas, independent, closed commas, report for AMP, which it turns out was more than 20 times amended by the client before being released. It's not exactly anyone else's idea of an independent report, is it?
I haven't seen the report. I don't know whether the change... Well, no, the answer to that, because the real simple question is no. If you pay someone to do an independent report, you would normally define their terms of reference, and at that stage you let them go. In a sense, a little bit like the Royal Commission. You define their terms of settlement. You say, go and conduct what you're required to do and give us a report. I would have thought 20... in one sense, even one change is wrong, but 20 it does cause concern, yes.
So it shows us how closely enmeshed the personnel are between the so-called regulator, because ASIC are not coming out of this looking squeaky clean either, the independent, in inverted commas, report of law firms who are in fact exchanging personnel with ASIC, with AMP. Everybody is basically it's a mates network of people helping each other out and pretending to be looking after the consumer.
Well, somebody once told me, John, that ASIC's enforcement budget was less than the public relations budget of one of the major banks, the PR budget. So, there's a report in today's paper that ASIC makes $600 million a year for the government. I had to do a company search in New Zealand last week. You know how much I paid? Nothing. It was free. Can't do a free company search in Australia.
There's an opportunity. Quick, tell the Kiwis they could be charging for that. They'll get onto it quick flash. But what intrigued me is that Clayton Utz have form on this stuff, and people have perhaps not got memories to remember.
British American Tobacco?
The British America Tobacco case led to intense scrutiny of skullduggery within Clayton Utz when they were in charge of the Orwellian-named document retention policy, which was in fact a mechanism for shredding the archives of the tobacco company before they could be accessed by plaintiffs suing them. And the document retention policy was no such thing. And then Clayton Utz spent more than 10 years suing one of their own whistleblowing lawyers.
Yes, they did.
Who is gagged. I've spoken to him this week and asked him to come on the radio, and he said, I'm not allowed to. And I'm not allowed to talk to you anymore. Goodbye.
Oh. Well, I see him from time to time, John. I'll go and have a talk to him.
Oh, we'll see if you can get a better answer than the one I got.
Whatever answer I get, I can't tell you. So
well, that's probably true too. So, I mean, this is not new news, but they being the
See, part of the problem, John, is that
the tightrope walkers, they keep getting away with it.
Someone has to pay the independent, and it might well be that you get. I mean, the regulator might appoint the independent and require the company concerned to pay, but at the moment it's the company that says we'll go off and get an independent report, and we'll submit it to you. I think the better answer is that the person who is to receive the report appoints the person, but then makes the other person pay.
All right. Now, it's also news on the front page of today's Herald Sun that Supreme Court judges have said it would be a breach of their independence to participate in a sentencing advisory council. It would be a muddling up of the judicial compared to the executive functions, the separation of powers.
I agree with that.
And they've declined to join in.
I must say the Herald Sun didn't take that view.
No, their headline is Supreme Court judges snub plan to give Victorians a greater say in sentencing, laughed out of court. The judges have said, well, no, you can set up a sentence advisory council. It's just not appropriate for any sitting judge to be on it.
Yeah, I agree with that.
Get some retired judges, get some academics, whoever you like, but none of us.
Yeah, I think that's right. The answer would be we interpret and administer the law. We don't want to... Well, the theory is they don't make it. In practice, they do around the edges.
Anything else that's new?
I had, in terms of new for legislation, yes, there was an amazing decision handed down in the Supreme Court, in the High Court last Wednesday, which will have an extraordinary impact at VCAT. What happened was there was the New South Wales have a tribunal like ours, a civil and administrative tribunal, and it has an anti-discrimination list. Somebody made an application in the anti-discrimination list against a resident of Queensland for some things that were said or alleged to have been said. The matter's gone all the way to the High Court to determine whether the tribunal has the jurisdiction to hear it or not hear it.
Sorry, whether the Anti-Discrimination
Tribunal in New South Wales has the right to determine a matter that arises between a resident of Queensland and a resident of New South Wales.
In other words, can they reach across the border?
Yes.
Yep.
No is the answer.
Oh.
And the reason why no is because a tribunal isn't a court. Now, I spent some time over the weekend trying to see whether I could explain in very simple terms the difference between a tribunal and a court, and I've got to tell you, I'm not prepared to give it a go. But in strict theory...
So a court can reach across a border, but a tribunal can't?
Well, in strict theory, a tribunal is part of the executive or administrative arm of government,
right,
whereas the courts are judicial side. Now,
so here comes that same distinction that the judges on the Sentencing Council...
Yeah, so here's a piece of legislation. The Constitution says that the High Court has jurisdiction between residents of different states or between a state of a resident and another state and a resident of another state. The Constitution then goes on to say that the Parliament may make laws delegating some of the original jurisdiction of the High Court to any court of a state. So the answer would be yes, the federal Parliament can pass on, can vest jurisdiction in a state court, but this says, the High Court says, can you vest jurisdiction in a state tribunal? And the answer is no, you can't.
Okay, simple solution, convert VCAT into a court.
Yeah, that
although it becomes VCAC.
I'm sure they'd think of another name.
I hope so.
But so that's the issue. So we have problems from time to time where people ring up and say, I ordered some equipment from Sydney and it came. Yep. Where can I take it? What's my jurisdiction? At the moment, that can be done in VCAT, or it could be done in VCAT until Wednesday, the 18th of April. Okay. And my last one was last week. We had a question from a driver on the Mornington Peninsula who's on some fairly heavy medication, and he wanted to know if he was to be involved in an accident and somebody died, what were his consequences? And if someone dies as a result of a car accident, the driver is normally charged with culpable driving, and a person drives culpably if she or he drives while affected by drugs to such an extent as to be incapable of exercising proper control over the vehicle. So the answer would be, if the level of drugs that you are taking is such that you can't exercise proper control, then it's a culpable driving charge.
All right. That may not be what they wanted to hear, but that's the answer. Tanya in Heidelberg, good morning to you. You're through to David.
Good morning. I've got a consumer rights question. We bought a car in 2011, and just before the warranty expired in June 14, we noticed that there was something wrong with the condenser. The sound changed, and they said there was nothing wrong. Then in December, the whole thing failed when we had it regassed, and we had to have it replaced in February.
We're talking about the air conditioning here, Tanya.
Air conditioning condenser, failed. So we had it replaced in February 16.
Yes.
And then I did think that it was starting to fail, but then I just thought I was being neurotic. But then again, in November 17, the whole thing had failed again. And originally, when we had it replaced, we just accepted that, there was some damage or something. These things happen. Mm-hmm. Then in November, we've got this awesome air conditioning guy, and he said, hang on, there is something wrong here. It's not anything that you've done, crash or anything like that. He said there's a fault in the condenser, and it's exactly the same as the last one that I replaced for you. And he said it's no damage, it's a fault in the condenser. So Jeep, because it's out of warranty, Jeep... Oh, sorry, I shouldn't have said that.
Well, you have said it 3 times now. Tanya, but keep going. Yep.
Yeah. they refuse to acknowledge anything and say that there's any problem with the part.
Can I say, Tanya, you do have a claim you can bring at VCAT? Because presumably you bought the vehicle in Victoria?
Yes.
But what you're going to need is expert evidence to say, in effect, that they sold you faulty goods. Now, the cars are getting more and more complex, so the answer would be there would be an expectation that these things do happen. You would need to get your expert to be able to say there was a fault with the vehicle or fault with the units, and if they put in a faulty unit, they can't expect it to last.
All righty, Tanya.
2 years wouldn't be long enough.
Great.
Thank you, Tanya.
Okay,
Go for it. David in Mount Waverley, good morning to you. You're through to David.
Oh, yes, good morning. I'm really ringing up on behalf of my son who bought a property in a city 3 to 4 years ago. He's had plans approved for an extension, and in the process he's had the land surveyor come out.
Yes.
And the result is that he's saying that, by the way, it's a single-fronted freestander.
Yes.
It's a house that's been built in about 1920, 21.
Yep.
The land surveyor said that about a metre, which is his hall side of the house, they can't work out who owns that bit of strip of land.
Yep.
And so we're wondering, would you be able to advise him what we do or what our next step is?
Well, let's take it back a bit, David.
Yes.
When back in the old days, we defined land by reference to each of its measurements and its distance from a point.
Yes.
When we created the transfer of land
to a point, meaning, for instance,
from an intersection,
a nearby corner or something.
Intersection, yeah.
Right, okay.
So I had a similar problem to the one David's talking about in Riversdale Road in Hawthorn. All right, now, so what we had was one surveyor who started his survey from the corner of Power Street and someone else who started their survey from the corner of Glenferrie Road. So different surveyors done at different times, and I had another one in Glen Iris.
But shouldn't they
didn't meet.
They should match up. That's the whole point.
But they don't meet.
So there's something wrong on the survey plan.
No, well, it might well be that the original point taken at one intersection or the other isn't where it ought to be, so everybody's out.
Someone's rebuilt an intersection, moved the survey point or whatever it might be.
I know that's an offence under the Survey Act to move a survey point.
Don't tell me it doesn't happen.
Oh, John, I've never seen it happen in my life.
No, of course not.
So, David, there is a process where you can apply for the title to that.
Yes.
It's not technically an adverse possession application. I can't remember the section under the Transfer of Land Act, but what you're really doing is seeking to amend title so that it matches.
Okay.
All right? So it is possible for you to get title to that land, but it's a discussion that you have with your surveyor, and if you like, I'll tell you what the section is under the Transfer of Land Act for next week.
All right, David, so tune in again. Marianne in Taylors Lakes. Hello, Marianne.
Oh, hello, David. I'm just calling regarding denial of access. I have been refused for myself and my telecommunications technician to check the integrity of a phone line or phone cord that services a landline and internet, and that runs
Where does it run?
on the side of a brick wall that is situated on a property line. Yeah, so the neighbour has said no.
So someone's come along when your property was constructed, and they've put the telephone lead or the telephone line, that thin cream piece of plastic, on the outside of the wall but on the neighbour's side of the boundary. Is that right?
Just to clarify, I am in Taylors Lakes, but the property is in Elwood.
Okay.
The property is early last century.
Yes.
And there's a phone pit, and the line runs, underground, and then it comes along a wall, sort of at the level of the air vent.
You have no right to access your neighbour's property.
What about my telecommunications services?
No access I don't think they have access to the property. So you don't. Well, I had a situation where where the damp course had failed. So a brick wall to the boundary, the damp course failed, and the people next door kept watering their garden, and it was my client's wall. We had no right of access at law to their property to fix the damp course.
Yeah, but this would be access for the telecommunications provider.
Well, unless the telecommunications provider has access under the Telecommunications Act, the answer would be no. But you personally have no right of access.
Well, it wouldn't do me any good other than to say I couldn't fix it. So
No.
I suppose the telecommunications provider... email
Yes.
has replaced the post as a postal delivery device.
Yes.
And wouldn't that be, by withholding permission, interfering with the delivery of mail? I mean, I can't
No,
see
you
such
could
an
you could get it
important-
wirelessly on your phone if you wanted to.
Can we deal with the fundamental problem? Why can't your neighbour be persuaded to do the right neighbourly thing?
I would have thought the neighbour would want the cable moved.
There is an issue. There's a drainage issue between the two properties. That is before VCAT.
Yes.
So you're already at loggerheads before this came along.
Oh, so I'm
Sounds like
now
yes.
I'm now appearing as if I'm implying that my neighbour has deliberately cut my phone line.
No, we're not suggesting that for a moment. And I don't think you are. There's a problem with the phone line. Do you have a right of access to your neighbour's property to check the phone line? The answer is the telecom company, the telecommunications company might under the Telecommunications Act, but you don't.
All right, Marianne, that's as far as we can go with that one. Margaret in Ringwood. Morning, Margaret.
Good morning, John and David. I have a little problem. My husband died 21 years ago. We held the property joint proprietors for our life. Then it went to tenants in common upon the death of my husband. And I have a life tenancy over his share.
Yes.
Now, I've done improvements to the property, which total now about $105,000.
Yep.
Over how many years?
21.
Yes.
He died 21 years ago.
So that's over a very long period of time then.
Yes. I've had, the paving done around the swimming pool because the concrete was all breaking up. Kitchen remodelled, laundry, parquetry floor, all things that will improve the property sort of long-term selling. And I'm just wondering when I die and sell, and my children and his children sell the property, am I able to get half of the costs of the renovations and improvements from their share?
Nope.
No.
No.
Oh, okay.
Now, what I guess what's happened is that there is no fund on your late husband's side that can pay or contribute to these costs. So it's a life interest to Margaret,
Right.
and the will probably say what you're required to do. Will probably imposes an obligation to repair. That doesn't mean improve; it just means repair.
Right.
And an obligation to insure will probably be there. If you choose to make improvements to the property, then the answer would be they're at your cost and at your risk. Although I should also tell you that if you're going to do anything substantial as a matter of logic, you need the permission of the executor of your late husband's estate to do the work.
Which is me and my stepson, who they, as my husband always said, if you think you've got a happy family, throw a will in the middle of the floor.
Yes.
And that's exactly what's happened.
But where you're at the moment, I mean, you could force the sale of the property. There's lots of things you could do, but you can't insist upon them contributing to the cost of the improvement works that you think enhance the value of the property.
Right. I just
Margaret, have you tried having some sort of mediation? Because professional mediators deal with these issues every day of the week and are often much more successful at bringing people together than the alternative of litigating.
It took us 2 years of mediation to get them to even put some money that he had, that was sitting in a bank account doing nothing, into an investment fund of which I get the interest, but they will ultimately get the...
But you did get there in the end, would be my response. So maybe it's worth just picking up where that ended up and saying, can we just keep that process and give it another burst?
Right.
Or
right.
indeed, can we put the money in the fund into the property?
Good luck with that, Margaret. I hope you're able to resolve things. It's not the sort of worry anybody needs as they're at the third age of life. Hans in Somerville. Morning, Hans.
Good morning, David and John. I got a quick question about auctions.
Yes.
When they advertise a property between 720 and 790, let's say, and it's sort of they start the auction and nobody's bidding, and then the auctioneer says, I'm bidding for the vendor,
Yes.
720, and then another bid of 740, and then the property basically gets passed in.
Yes.
The question now is, the reserve price was way above that advertised price. So can they do this, or?
Well, the reserve price, there's two parts to the question. The displayed price is based on the estate agent's estimate of the value of the property.
Right.
All right, and they are required to give you documentation in relation to comparable sales and other information that justifies how they arrived at that figure.
Yep.
It doesn't mean that the vendor has an obligation to sell at any figure within that range.
Okay.
Right, so it's what you might say is that in the situation you're talking about, the agent has been honest in their estimate of the range, but that the vendor has not, in a sense, played the game or has a view that the property's worth substantially more. Thank you, Hans.
The other question was, when the property gets passed in, and then afterwards, how they'll list property sold and not sold.
Yes.
Then it came up as sold at auction. Is that legal?
Oh, sometimes that's just marketing, isn't it, David?
Well, it might have been sold after auction. I mean, somebody might have come up after auction and bought the property.
Yeah, and in the negotiations immediately after the falling of the non-falling of the hammer in this case. All right, Hans?
Okay.
So quite often, John, you'll find that the property is sold in a couple of hours after the auction. And
negotiations.
So yes.
Chuck another couple of grand in and it's yours, sort of thing. Morris in Bacchus Marsh, you'll be our last caller, I suspect, this morning. We're running out of time. Good morning, Morris.
How you going, mate?
Good. Go ahead.
Yeah, a few years ago, a mate of mine said we could leave some farm machinery on his property.
Yes.
As long as we helped him around the farm doing what he wanted to do.
Yes.
So we did that. We, we slashed his property. We put a crop in for him. We baled it. And then my young bloke bought some land up in the edge, and he wanted to take his machinery off.
Yes.
Take it up his place and start using it.
Yep.
Well, that was all right. And then the bloke I know, he said, look, I want you to leave the tractor and slasher here. And my son said, how long for? He said, about a month. He said, yeah, righto, because he wanted to slash his property.
Yep.
So after 9 weeks, we went out and said, right, we're going to take the tractor and slash away. He said, no. And he locked the gates and said, I'll call the police. I said, yeah, righto. So he said,
Morris, you have an action, what the law calls is an action in detinue, DETINUE, and it's an action for recovery of specific items. It's a proceeding you run in the magistrates' court, and it requires a formal demand before you sue. But the answer, you have none of the personal property security issues that might otherwise arise appear from what you've told me. Mm-hmm. So that's the process, magistrates' court.
How much is the equipment worth, Morris, if you were to buy it or sell it?
Oh, it's probably, there's what's left out there's probably, there might be $5,000 or something worth.
So is it worth your while seeing a lawyer, getting a letter of demand, it's called, written to the property owner, followed up, if necessary, by a summons to come to court to explain to the judge why they seem to think they can hang on to your stuff?
I'll have to talk to a solicitor and see how much they charge, but it's
I know, it's why would you walk away from the equipment in $5,000?
You can't.
You can't.
No.
I can't have the discussion.
Yeah.
Thank you, Hans.
Right.
And a lot of the time, David, these things will be resolved just with the shot across the bows that a bit of letterhead provides, showing that you're taking this seriously enough to go and pay a lawyer to write the letter just to get the ball rolling.
Yeah.
And hopefully that might work in your case too, Hans. Hopefully that'll work in your case too. David, thank you. We've got through lots and lots of calls this morning.
Thank you, John.
And of enormous variety as well. Look forward to seeing you at the same time
next week.
Next Tuesday. David Whiting, our talkback lawyer, helping you with free legal advice.